September 27, 2012. This is Justice Done Dirt Cheap in Fredericton, New Brunswick, Canada. I want to make a specific point today, and that is no notice of prosecution equals no jurisdiction. What that means is in New Brunswick there's three types of courts. There's Court of Appeal of New Brunswick, which is a court that hears appeals of lower court decisions, and those are decisions from Court of Queen's Bench, Family Division, Trial Division, Provincial Court, both bylaw matters and criminal matters. Now, the next level of court down is Court of Queen's Bench, which is considered a Superior Court of New Brunswick. The Court of Queen's Bench is an amalgamation of several other courts that existed before they were combined into one court called Court of Queen's Bench of New Brunswick. Then the next court down is called Provincial Court. Now, Provincial Court hears matters both criminal and quasi-criminal, which would be bylaw matters. Now, courts are either superior courts or inferior courts, and the distinction is superior courts are assumed to have jurisdiction unless it can be shown otherwise, and inferior courts are courts that are assumed not to have jurisdiction unless that jurisdiction can be specifically pointed out by statute. So now that we've made that distinction, a provincial court hearing bylaw matters gains jurisdiction according to the Provincial Offences Procedures Act, conditional to the procedures being set out in that act being followed. So it's pretty simple. If the court does not follow proper procedure, the court does not gain jurisdiction over the issues. According to the Provincial Offences Procedures Act, under the section titled Tickets, where bylaw matters are dealt with, the procedure is simple. A police officer or bylaw enforcement officer who wishes to serve a ticket on someone must at the same time serve a notice of prosecution which corresponds to that ticket. There must be a date on the ticket that states the date that if someone wishes to contest the ticket, they may appear to plea. Now, one can either plead guilty or not guilty at the plea hearing. What's important though is that a provincial court does not gain the jurisdiction to issue a summons under the Provincial Offences Procedures Act until someone fails to appear at a first plea hearing. Now that's under the section called, or titled, Failure to Appear. It's pretty simple. It actually states if a procedure was commenced by notice of prosecution and a defendant does not appear at the first hearing, a solicitor representing the other side may ask the court to just deem the individual guilty, or may set the matter down for trial at a later date. But the judge has the discretion to either issue a summons to compel the defendant to appear on the matter, or issue a warrant if the conditions require it, or in the judge's opinion, the conditions require it. So, and then if there's a second hearing, it's a similar circumstance. The individual doesn't appear, the judge can either issue another summons to appear or a warrant. So the procedure is fairly straightforward. Now, what has been revealed is that in the province of New Brunswick, in my own situation specifically, and other people I've talked to, and this has been confirmed by Constable David Beck when I cross-examined him under oath on the stand September 21, 2012, that he as a police officer has never seen in his entire career a notice of prosecution. So he has been proceeding procedurally incorrect the entire time. On that same day, on the record, the judge, Mary Jane Richards, admitted that there was no notice of prosecution before her that day. There has been no notice of prosecution filed in this file, and she was unaware of there even being a requirement for a notice of prosecution. She was unfamiliar with the act and that aspect of the act. And as far as she knew, these procedures were always started by laying of an information. Now, it's important for the viewer to understand, laying an information is not the right procedure. It's the wrong section of the act, and the consequence of laying an information is one could be facing jail time, because once you're in that section of the act where information was laid, the judge has different powers or jurisdiction. So it's the consequences can be severe for individuals. One could actually be facing jail time for a simple parking ticket or a menial bylaw infraction. Now, I have not consented to following along with the erroneous procedure. I don't agree with it. I provided by affidavit to the court my legal position. I do not consent to go along with these erroneous procedures. It's pretty simple. I'm not participating, so get used to it. Alright, so that's a little information package about the importance of a notice of prosecution being filed when the city of Fredericton or any other municipality in New Brunswick wishes to collect revenue by issuance of a ticket for bylaw infractions. It's pretty simple. It's written in legal English, not plain English, but it's available for anyone to view on the Government of New Brunswick website, as well as CanLII, You can go look up the act yourself. It's Provincial Offences Procedures Act, and the two sections that are very relevant are a section titled Tickets and a second section titled Failure to Appear. There's different procedure whether an information was laid or a notice of prosecution was filed. Jurisprudence on the subject has established that a statute says what it means and it means what it says, unless something can be shown to the contrary, and one should use the plain meaning rule to interpret statutes, which means if there's a procedure that's obviously stated in a statute, that's what either Parliament or the Legislative Assembly, in this case the Legislative Assembly of New Brunswick, intended. That was brought into place by representatives of the people who were voted in positions of power to vote on legislation. They agreed on the wording of the act. It's not for municipalities to just do whatever they want when it comes to collecting revenue from bylaw infractions. So that's why I started this video with a no notice of prosecution means no jurisdiction, and I verily believe that to be true. I'll put a little link to an article on the subject so you can read through and read the different portions of the act and make up your own mind. Do you agree with my legal position, or is there some flaw in that? I'd appreciate your feedback. Thank you for listening. Have a great day. This is Justice Done Dirt Cheap for New Brunswick, Canada.